When someone passes away, a will can bring out the best in the family, but sometimes it brings out the worst. Old resentments resurface. Someone feels left out, and then the fight begins. Maybe you believe that a loved one's will does not reflect their true intentions. Or maybe you're defending a will that is now being attacked by a disgruntled relative. Either way, you're in the same place, a dispute over a will. I am Asthana at Southern Estate Lawyers, and we handle will contests across Alabama on both these sides. Let me walk you through how these actually work. A will contest is a legal challenge as to whether a will is valid. It's not about whether the will feels fair. And not just anyone can bring that contest. In Alabama, only an interested person can contest a will. That could be someone that's named in the will, or someone that would inherit if the will was considered invalid. A distant relative who would not inherit either way usually has no standing to challenge a will. Under Alabama law, there are four grounds based on which you can challenge a will and bring a will contest. The first is a lack of testamentary capacity. The testator, who is the person that created the will, must have testamentary capacity at the time that they signed the will. At the time of signing the will, they knew what property they held. They knew what they wanted done with this property. They understood who they wanted to give this property to, and they understood the results of their choices. Under Alabama law, it is presumed that the testator had testamentary capacity. And declining mental ability or memory loss does not necessarily mean that legal capacity is lacking. Capacity is judged at the time of the signing of the will, not before and not right after. The second ground is undue influence. This is when someone in a position of trust pressures or manipulates a person into signing a will for the benefit of that influencer. The third ground is improper execution. Alabama law requires a will to be in writing, signed by the maker, and signed by at least two witnesses. Miss those formalities and your will can fail. And the last ground is any other valid objection to the will. Alabama law leaves the door open for any other valid objection, such as fraud, forgery, a will executed by mistake, or a will that was previously revoked by a testator. Here's the part that most people underestimate. Alabama law presumes that a will is valid. The burden is on the person that's bringing the challenge, and suspicion is not proof. Saying that a caregiver had a chance to influence someone is just an opportunity. It doesn't show that that actually happened. Saying that someone was sick when they signed is not the same as proving that they lacked capacity at the time that they signed the will. A weak will contest brought over hurt feelings can often be dismissed quickly before it ever sees a trial. A strong will contest is built on concrete evidence, like medical records, testimony from the physician, witnesses, and the circumstances around the signing. Timing in a will contest is everything. Before a will is admitted to probate, its validity may be challenged in the probate court as part of the proceedings. And depending on the county, any party may seek to remove the process to circuit court as provided by Alabama law. Once a will has already been admitted to probate, an interested person has 180 days from the date that the will was admitted to probate to file a contest in the circuit court. There is an important distinction to make here. Probate courts that have equity jurisdiction, where the judges are lawyers, for instance, courts in Jefferson County, Mobile County, and Baldwin County, you have to file your will contest in the probate court, and the whole litigation will happen in the probate court, not circuit court. Now, some wills have what's called a no contest clause. That clause says that if you challenge the will, you will lose your inheritance. In Alabama, whether that clause actually holds up depends on the facts. If you bring a challenge in good faith with good basis, the court may decline to enforce the clause against you. Depends on the circumstances. But a frivolous challenge brought out of pure disappointment could trigger that clause. This is the exact kind of risk to weigh with an attorney first. If you are the person that is trying to protect a will from a future fight, the planning you do now matters enormously. A will that is properly drafted and executed pursuant to the formalities of Alabama law is far harder to attack. In Alabama, a handwritten will with no witnesses is not valid, and a downloaded form that ignores Alabama requirements can hand the challenger the opening that they need. Doing it right the first time is the best defense there is. So, what does a will contest cost? At Southern Estate Lawyers, we understand that will contests can be financially unpredictable. So, we offer flexible fee arrangements. Depending on your case, we may work on a retainer with the remainder on a contingency fee. Or it could be a retainer built on our hourly fee. Or in some situations, a full contingency fee arrangement. We will review the facts of your case and walk you through the options that make sense for you. Will contests are what we do. We represent people challenging a will and those that are defending one. We are active trial lawyers in both probate courts and circuit courts across Alabama. We investigate the facts and witness evidence and tell you honestly whether you have a real case. If a contest can be resolved early, we push for that. And if it has to go to trial, we're ready to do that as well. We have offices in Mobile, Birmingham, and Foley, and we serve families throughout Alabama. If you're facing a dispute over a will, do not sit on it. The deadlines in these cases are short and unforgiving. Whether you're challenging a will or defending one, call Southern Estate Lawyers for a free consultation. We look forward to working for you.